Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com.
Hi everyone, welcome to episode 112 of the Immigration Lawyers Podcast. In this episode, I'm going to be talking a lot about the things I've learned recently and changes in the rules, for example, with the public charge issue. A brief thing, I'm not going to really go into it as much because other colleagues have done a much better job and I'm still a couple hundred pages into it, still some left. And then some court decisions that were interesting, but I thought there just needs stuff for practitioners to think about. They're the issues that pop up for all of us. So, starting with the public charge situation, it kind of came out of nowhere because we were expecting it the shoe to drop for a long time, and it didn't happen. And then Steve Miller and his minions all of a sudden issued it, and it was a pretty terrible decision and terrible thing. And there's lawsuits that are going to push it back, and I'm sure there's going to be changes on this because apparently there is no standard for the affidavit support now. They've made it kind of belligerent in the sense that they could do whatever they want to do now at DHS. We'd already been seeing this stuff at DOS. I had a colleague who had a case go for an immigrant visa interview in a South American country, not CDJ. And they had a joint sponsor, and the embassy's response to the interview was that your joint sponsor barely makes more, and they use the term barely makes more than the I-864P minimum. So because of that, you have to find a new joint sponsor. So you're seeing this kind of stuff happening, but this just made it so that DHS is also going to be doing the same kind of stuff. And it's going to be a tricky situation. My belief is a partial reason for this decision and to this kind of stuff is the president wanted to get rid of the program for U.S. citizens to be able to apply a petition for their parents. And the public charge rule does a great job behind the scenes to stop that. So they couldn't go straight forward and change the Immigration Nationality Act through the legislature because that would have been too tough. But by introducing public charge and saying whoever's over 61, we're going to hold that against them, and they're going to potentially come here and use medical benefits and the like. That's going to make it harder for those immigrant visa cases to be issued or adjustment cases to happen. And so they get what they want without directly changing legislation. And that's very troublesome when there are statutes that allow something. We really need to, instead of just attacking the executive and what they're doing, is push the legislator to act. Unfortunately, comprehensive immigration reform is too hard to change. It's so big, but with this things here and there, especially for something like public charge, making it, they even in the administration's own decision, they said that there's no definition for the public charge. So we have to do our best to have good definitions ready made to introduce to Congress so they could take the reins and make these decisions instead of leaving it up to the agencies and departments to do that, because it's a big problem that happens. The next thing that popped up, which was kind of crazy, was the U.S. Embassy in France issued a notice that the reciprocity charge for E2 or E general investor visas is going to change so that the timetable that an E-visa can be approved for a French national come to the U.S. will just be 15 months. And so that's a really drastic change because before it was 60 months, 5 years, and that would give the investor a lot of opportunity to grow their firm before they need to, or grow their company before they need to go and request a new visa. But with 15 months, that means as soon as they get here, they got to get things up and running quickly. It's almost as if it's a new office L1, and then go back to get a new visa or maybe do an extension of status in the U.S. The idea of doing an E2 through the embassy or E through the embassy nowadays isn't that good, at least for France. Extension of status makes more sense because you're going to get potentially a longer I-94. I'm not really sure how the I-94 would be affected if the reciprocity charge is less. So that's kind of a weird situation. Then again, I think Iran has a visa period of 3 months, and once they come here, they can do extension of 2. So even if the reciprocity charge shows a less time, DHS will still give 2 years. So that's what you have to do. For French cases, extension of status is the way to go. And if they need to leave, it's going to be a big hassle getting a new one approved. It already has been, but it's going to get even worse. Now, they're saying that they're doing this because France, they're matching what France does for U.S. investors there. I'm not sure if that's the case. But this idea bringing shorter times for E2s has been tested. I've been hearing from colleagues dealing with London, that London would issue 1 year, 2 year E2 so that the investor was forced to come back to the embassy, show them what they did before they were able to go back to the US and continue their business, to make sure the E2 wasn't used as a tourist visa. So what happens to people who already have 5-year visas? Do those visas get canceled or changed and stuff? I'm not really sure. I think I'm not really sure what happens to those kind of stuff. So hopefully there'll be some guidance on what to do with that. Now, with regard to the travel ban, I had first successes this month getting 2 travel ban Iranian cases approved. One was a spouse of a lawful permanent resident, the other a parent of a U.S. citizen. So that's exciting. Now, I don't submit waivers with my petitions or applications for consular processing. I know everyone else says you have to do this and that, but I've submitted waivers for many cases that didn't go anywhere or weren't even looked at by the consular officer. So I just tell my clients to be able to explain what their situation is to the officer. And my feeling is I didn't do anything special in these cases to get them approved. It seems like there was some internal memo going around inside DOS, Department of State, that said approve them for now. I think it may be a strategy of theirs to approve some cases to boost the statistical numbers they have. So in case there's a lawsuit, they can say, no, we've approved cases, look, here, here, and here. I mean, it's kind of obvious that all of a sudden overnight they turn this stuff on and have cases that are pending 2-3 years still in administrative processing or because of the travel ban, and nothing's gone forward. So I'm not sure if that's going to be a good strategy, but for those families that it does work, it's a big deal. Now, I-131 advanced parole. I went through a big headache, which used to be an easy thing. So I had a client that needed to get emergency advanced parole. We had petitioned. He's an EB1 beneficiary, waiting for the priority date to become current so he could adjust status and the like, and his existing I-131 was going to expire. So we filed for a renewal, just a basic extension of the I-131 advanced parole, like 3 or 4 months beforehand. And we're coming up on the expiration of the existing one and still nothing. So he's like, let's do emergency advanced parole, I need to travel. I said, no, it's a big headache. It's gonna cost you a lot of money, a lot of this and that. I really didn't even feel like doing it, but he's like, no, I need it for business purposes. So I said, okay. I called up the 1-800 number. I said, this guy's situation, he has a pending I-131, nothing's happened, he's got business necessity, he needs to travel. And the first person said, okay, no problem. Took my information down and said within 24 to 72 hours, someone's going to contact you. I said, okay, that sounds great. So, 3-4 days go by, nothing. So I called back the 1-800 number, and mind you, the first call took an hour to finish it. The second call, about an hour to get hold of somebody. And the person that picked up said that, no, we can't do emergency advanced parole unless the need for travel is within 5 days. And so that didn't make any sense to me. Is like they made up this regulation. I said, well, let me talk to your supervisor, next tier 2 officer. And they're like, okay, please go on hold. And then they transfer me, and then all of a sudden it says, the voicemail you're looking for, voice message box is full, you cannot accept messages, and hung up on me. And so that's just rude. I think the film maybe did it on purpose because that is so stupid that they did. But so I hung up, and then I called this again immediately. And by this point, I was like 2 o'clock in the afternoon, 2:30 in Los Angeles time. And the officer, the third officer, after an hour of being on hold, by that point it was like 3:30, said like, it's okay, we could issue it. Let me transfer you to a tier 2 officer to see why they didn't call you, see what happens. And then when he can't do that, he said, oh, actually, all the tier 2 officers left. You can't do anything anymore. Call tomorrow. So far, 3 hours wasted. So the next morning I call, a 4th hour wasted, and they said, oh, okay, we'll have someone call back you immediately. It'll be from a 202 number or something. I think it's a DC number. Apparently, these scam artists have been spoofing USCIS's phone number and calling people with it. And people, with the caller ID would show USCIS, and they get scared and pick up and get credit card information and the like. And so they changed it and say it'll be a 202 number that's calling you. And one thing they always say is when a tier 2 officer is going to contact you or talk with you, here's the code that they should repeat to make sure that there's going to be no fraud or someone faking it. But I've never had a tier 2 officer ask what that code is, and then we just talk. So there's an inconsistency in their own security procedures right there. But so the tier 2 officer actually called me back within half an hour, and we scheduled a time really quickly, and so that was nice of them. However, I asked, could we come on a Thursday or Friday, and they said that field office that we're going to in San Diego, actually, the thing is closed. They're closed for InfoPass appointments on Thursdays and Fridays, and that was kind of weird to me, but I said, okay, whatever, I didn't have time to argue. I said, we'll come the next Monday. So hung up. was able to go there Monday. San Diego staff everyone was really polite, nice. It was just a good experience. Sometimes you go in there, you got to fight with them, but everyone's really kind. So I got the kind words to say about the San Diego InfoPass appointment office. Advance Parole was issued immediately. I mean, it takes time, like 2 hours of waiting for them to process it, but the initial conversation that come with 100 pages of explanation, this and that, and we just talked to them and said, hey, this is the situation, we're waiting on Advance Parole. We thought we'd get it by now. It was an L1, EB1C kind of thing. And they said they travel, they're forcing him, he doesn't want to go, but he has to. And they're like, okay, I understand. And so it worked out. So it was just frustrating that I spent about 4 hours on a phone just to get an appointment set up, and one officer just said, we can't do it, even though when we had already scheduled, said they would. So that was kind of weird. A week later, Los Angeles had their new stakeholder meeting. So I guess the relationship between AILA and USCIS got bad. So at least in our local field office, we used to have monthly meetings. They stopped those about a year ago or 6 months ago or something like that. But now they have public quarterly stakeholder meetings. So I went to the stakeholder meeting that popped up, and they have people from the Social Security office, from the passport office, various local office, people at our local field office, the USCIS. They also had a person from the 1-800 number there. So he came and spoke first, and he said that we're scheduling InfoPass appointments within like 4 hours or something like that. As soon as you call in, we call you back. And I was like, oh, no, no way. So I raised my hand. I'm like, that's not true, this. And a couple other people raised their hand in the same situation. He's probably some higher up person, and they tell him lies and he repeats it. But or they mess up these statistics and tell him bogus stuff. But I spent 4 hours, of my time, on client's time, on their dime, and it's not fair to people and just make up rules like that. So I told him what the scenario was and said this isn't true. And he's like, I'll look into it. Probably nothing's gonna happen. But that's the situation, and it really just brought to mind, like, why do we need an advance parole for an adjustment of status case that's pending? Now, I know if they want to re-enter the country, they need to have some sort of travel document, but why do we have to wait for advance parole to be approved? Why shouldn't that just be part of the receipt? Kind of like when you do removal of conditions for a marriage-based case and the receipt is an extension of your green card. How come they can't send a thicker page, blue paper, whatever color it is, that said advance parole, just to let people travel, at that point? If there's a fear that people just will fly in, do adjustment of status, and then fly out and then wait it out, well, there's immigrant intent issues, there's like misrepresentation of the intent when they enter, all this kind of stuff exists. I mean, for H-1B and L-1, there's that dual intent statute that lets you travel on those kind of visas, even if you just come in. So, and there's no need for advance parole to take that long. Even EADs, what is the need to process these? You issue them, and then if there's problems, you can take them back later. But I don't know, maybe I'm open to suggestions, or maybe I don't know all the information, but that's really annoying. Like, I had another colleague of ours say that she was requesting an expedited advance parole, not emergency, and they denied it because they said the I-140 was still pending. So they made this requirement up, which I didn't know, that if you have an I-140 still pending, they won't issue an expedited advance parole, which it doesn't make sense to me, because I've had cases like that we got advance parole. So they just make things up as it goes along. And the officer on the phone said there'll be a filing fee for emergency advance parole. And I talked to several colleagues. Some say, yeah, sometimes they do charge, sometimes they don't. So there's an inconsistency in that procedure as well. So there's just way too much inconsistency in this whole system that you can't rely on it. And what makes it hard on a practical level for you as practitioners is how much you charge. I didn't expect to talk on the phone for 4 hours. We do flat rates. Maybe I should do hourly rate later, but just to get someone to do an appointment took 4 hours of time. And so obviously I didn't get paid for all that, and it pushed off all this extra stuff. I mean, it pushed off the podcast. I couldn't do it because I was like messing around doing this, and I have to drive to San Diego. That took a half a day or a whole day pretty much. And so all this stuff affects practice, and it seems like this rebel brand of anti-immigrant people in the administration. I think one thing they're trying to do is mess with attorneys, because they know if they try to wear us out, it'll make us harder to represent our clients, but little do they know that's only going to encourage us to fight back more. So the lawsuits are increasing. I'm doing my best to train more and more immigration attorneys, people from different fields I'm training that come into immigration law with this attack mode of saying, hey dude, like, this is just legal stuff we're doing. Put aside the hatred and the racism. There's some cases that are validly denied. We accept that. It should have been filed. There's issues. Whatever the situation is. But with regards to stupid stuff like this, if we need to fight back, we're creating funds to fund lawsuits. We're creating groups of litigators that are ready for this. Honestly, it's coming out. So there's no need to fight. We could put aside the animosity and the hatred, and we could work this out. Or not, we got to do what we got to do. And that's what seems the direction of things going. I wish it wasn't like that, because there are good people. Like I told you, I went to San Diego. They were so nice there at the InfoPass appointment. I hate to have them be caught up in the middle of this kind of stuff when it's like a political decision that gets put on them. But unfortunately, that's just the nature of our times right now. Now, with regards to visa statistics, a colleague shared with me on travel.state.gov. They released an annual report of what is it called? FY. They call that FY is financial year 2018 report on visa statistics. And there are two interesting statistics. One is, or three actually, is there was a massive drop in student visas in 2018, unfortunately. I think like 100,000. There was a giant drop in K1s as well. And so that threw me off, like, why are K1s dropping, K1 visas dropping? It might be because of the delays that just popped up in K1s and not being adjudicated as fast as they used to. So that causes the visa numbers, or the use of those visas, to lessen in FY 2018, so it shows that. But also what's interesting is the increase in O1 visas that's happening, and I guess people are using the O1 as an alternative to the H1B or potentially the L1 because of the delays and denials and noise and all that kind of stuff that are coming from those. Now, I've been talking about this issue about tax returns and tax transcript from the Department of State and whether it's a rule or not. AILA had a liaison meeting with them in April, and DOS said that you could provide transcripts in lieu of the tax return, but to them it's not a requirement, but it's recommended. But the thing is, they also said that if an embassy or MDC, whoever, does request a tax transcript, you have to give it. So they're like, it's not a requirement, but if we require it, it's required. So it's kind of BS. So the thing to do, best practices, is to right from the beginning, just get the tax transcripts from your client and use those, and don't bother going the other way. Now, the embassy in London did issue a statement saying, no, we will accept tax returns, but at the same time, they also say we need tax transcripts somehow. So it just makes sense to get the tax transcripts. They're being way too inconsistent on this to not to try the tax return. Now, the issue with tax transcripts is that it's gotten harder to get. Like if you have a foreign address on your tax return, they might not issue a tax transcript. There's issues with them faxing it over or mailing it. Their website doesn't work sometimes it takes forever. So it's like a big headache getting that together. But if it's easy enough, a client has basic W-2 income, 1040 easy that they do or whatever, just request a tax transcript and get that going to avoid any issues from happening. Now, I had one of the cases I had for immigrant visa interview, related to tax transcript. We filed the MDC stuff before the new fiscal year, whatever the tax return year was. And so I told the clients, take the tax return and tax transfer with you to the interview to show them. And historically, we would just update documents with the embassy at the immigrant visa interview by just handing him, pay stubs, updated I-864, all this kind of stuff to take. But at this interview, the consular officer said, you know what? Go back home, upload, because they handed them stuff. They're like, scan and upload these to CEAC. And then come back to finish the interview. So instead of my client just giving it to them doing it, they had to go back home, upload the documents, and it was middle of the night here, so they emailed me, but I was sleeping, I couldn't catch it, or else I would have done it for them. They uploaded the stuff, and then they went there and they did it. Now I have another case that's about to go to interview where it was the beneficiary, the immigrant visa applicant, had gotten, her spouse had died. And so on CEAC, we had uploaded the divorce, the death record for the spouse. It was under divorce document because they didn't have an option for dead spouse, death of the spouse. So I used it under, how the marriage ended. And so then the interview's coming up, and after this transcript situation happened, I just went and opened up their CEAC page, and I saw that they said missing documents, a death certificate of spouse, even though we had uploaded under the divorce. So they couldn't take the time to look at it, even though it's translated to say, oh, this is it. We didn't have an option that at the time, and now the new option is open. And I kind of get the feeling that CEAC deletes stuff sometimes. I'm sure I upload some stuff, but then all of a sudden they'll say missing documents. And they've gotten really strict on quality even more than they had before, where like I'll have a passport page and like it's not clear enough, resubmit it. And it takes them like 3-4 weeks to tell us that. So it causes huge delays when this kind of stuff happens. So it's really hard. It's really hard because these people's lives get pushed back a whole year. So it's bad. Now, I want to briefly talk about what happened in Mississippi a few weeks back ago. There was a huge raid, and I think it happened by HSI instead of ICE. But it was a meat packing plant or chicken poultry packing plant, and it was like a bunch of people there who didn't have status and didn't have work permits. They picked them up and took them away, and it's a rural area in the middle of nowhere in the south. So they're going to have a big issues because there's not enough immigration lawyers there to help them with these kind of removal proceedings. There's already not enough immigration lawyers in general, let alone for that area. And also, who knows if these people have the funds to do it. Right now, they're not working, and they have families. They barely have enough money to support themselves and to pay lawyers to do the highly stressful and time-consuming job of removal defense. So that's an area that's a shame, and hopefully there'll be a lot of groups that do pro bono kind of work and organizations that go there and help sort this out. Now, some of the people will get removed, whatever the law is the law, but there's always people in that mix who did have lawful residency status or a chance at it, or cancellation or something like that, and so they need to be at the representation that they need. Now, to a couple more stuff before I finish up, a colleague had said they had done an O1 in London, and typically when they would go to the interview, the clients would just say, you know, what do you do, how much money do you make, this and that. But this time the officer was more detailed, and they say, what do you do and how do you do it and who are your clients, and they went on their website and they checked it out. And so something they recommended is to make sure to check the client's Twitter, Facebook account, all this kind of stuff to make sure the information is consistent, the job titles, the work that they do. Just check this stuff out and make sure, for example, their LinkedIn has the correct bio history that matches what they said in their O1 resume, so that's not too far off, you know. But that was it with that. The last two things I wanted to talk about are two court cases that are positive for immigration lawyers. The first one was about, and our clients really, was about the travel ban. Apparently, when the second of 3 travel bans was instituted, there was some sort of hold place, or the case was going to the Supreme Court, and there are people who had their interviews for the travel ban, and they were denied there. And they had sued, saying that you know, we should put aside these visas, because, you know, for a diversity visa green card lottery, which were these cases, if you don't issue the green cards by October 1st, they get deleted, and that's it for that year. They have petitioned the court and say, hey, please hold on to these visa numbers to see what happens with the Supreme Court, because if the travel ban is overturned, then they could have issued these visas, and there are citizens from Iran and Yemen who did this lawsuit. And the district court at first said, no, it's all good, but the DC Circuit Court issued a statement and said, you know, just highlighted, the plaintiffs file suit and the court grants some relief. I'll start from the beginning, actually. It says sometimes a plaintiff files suit before the selection of the fiscal year ends, but the court fails to act on that request until after September 30th, at which point the State Department lacks authority to issue a diversity visa sought in the prior fiscal year. Courts have likewise dismissed these cases as moot. Other cases involve a different twist. The plaintiff files suit and the court grants some relief, but not the visa, before October 1st. In such a case, after the selection fiscal year has ended, the court might lawfully take steps to compel the government to process the plaintiff's applications and issue her a diversity visa anyway. And that's what happened here. On September 29th, the district court ordered the government to reserve unused fiscal year 2017 visa numbers so that if it turned out that the plaintiffs had been erroneously denied their diversity visas, the court could order the government to process visas for plaintiffs past the statutory deadline. The question is whether, now that the selection of fiscal year has ended, the district court can order the State Department to do anything with the unused visa numbers held in reserve pursuant to the September 29th order. We hold that the September 29th order need not be read to limit the authority of the district court to grant additional relief to a scenario in which the Supreme Court finds the executive order number 2 to be unlawful. Rather, it is at least possible to read that order as doing one or both or 2 other things. That is, the order could be read as instructing the State Department to hold these unsafe visa numbers for purposes of enabling a later judicial judgment, which might require the government to process plaintiffs' applications after any salient obstacles are removed, and to identify the specific judgment that would issue if Supreme Court took a certain action. So essentially they're saying they should have kept them because they had filed this injunction in time. So that was good. Those people got to go back to the district court and try to sort it out to see if it would work. I'm not really sure what happened after that. It's a recent decision. But the other one, is the last thing I'll talk about, was really interesting, and I like the government's language in here. It was very satisfying personally. This one, actually, Ira Kurzman was arguing this one. It's a Third Circuit Court decision opinion from August 15, 2019, and this is about F1 student visa fraud. So what happened was these fake universities were created by DHS in 2013. They never existed. They're sham universities, and it was a scheme that DHS created to catch brokers of fraudulent student visas. But it also ensnared hundreds of students. And initially, the government said, you know what, these were innocent students. We weren't going after them, so we're not going to have problems for them. And so, but then they turned around and changed course, said no, actually they're part of the fraud too, and they're going to be denied and the reinstatement, all this kind of stuff, and there's going to be fraud listed on their CVIS record and all this kind of stuff. So that was really messed up of them to like change things around. They say on October 12, 2018, the government changed course yet again. This is first saying they're innocent, and it said it filed a letter to clear up any confusion from certain exchanges that occurred during argument. So in the public argument, they said one thing, then they later changed it. It's just so despicable. The government informed the court that it was not, in fact, conceding, quote, that all or even most of the enrollees were innocent victims, unquote. In fact, the government now asserted that some of the students, in all likelihood, knew that their academic recruiters were committing visa fraud, and others even conspired with their academic recruiters to commit visa fraud. Thus, the letter concluded, to the extent that any of the government's comments at oral argument left the misrepresentation or misimpression that all of UNMJ's, the school's enrollees, were innocent victims of the academic recruiters' visa fraud schemes, that is not the case. So the lesson you learn from here is don't trust the government. If they say one thing, they're going to do another. Even though they're regular human beings that get caught up in that, the machinery of the government really twists what they do into doing wicked stuff like this. The court was really good, though. It says, I'll just keep reading of the notes I took. Despite the government's position that these students were the victims of fraud, it acknowledged that database entries for each student would reflect the fraudulent enrollment determination made by DHS. The government acknowledged that it was able to, consistent with its stated position, eliminate any database notations that suggested that the student had committed fraud, yet it refused to do so. It argued that correcting the record on a preventative basis was not necessary because the fraudulent enrollment determination would have not had any adverse impact on the students in future immigration proceedings. The district court granted the motion on both grounds, so the district court granted everything the government wanted. It first concluded that ICE's decision to terminate the student's F1 status was not a final agency action. So this is where it gets really important. It said it wasn't a final agency action to terminate the student's F1 status, quote, because their applications for reinstatement were still pending. It explained that the initial decision of terminating plaintiffs' visas cannot be seen as final, given that ICE is currently in the process of deciding if plaintiffs are entitled to reinstatement of their visas. It found that the termination decision was more akin to the beginning of an administrative proceeding than enacting a final action. So the district court said that because they were trying to reinstate that, there's no final action committed on the case. It was still pending, so it shouldn't have gone to district court. But the circuit does great work. They say, we disagree with the district court's conclusion that the order is not final because the students are either seeking reinstatement or could seek reinstatement in the future. Nothing in the Immigration and Nationality Act or the Code of Federal Regulations requires a non-immigrant whose visa has been terminated to seek reinstatement as a form of review. The reinstatement regulation itself notes only that a student, quote, may not appeal, unquote, an unsuccessful attempt at reinstatement. In short, reinstatement is not a prerequisite to judicial review. It is neither expressly required by statute, nor does any administrative rule require your appeal before the review, and the administrative action is made inoperative pending that review. So this is good stuff. They go on to say, we similarly hold that the reinstatement proceedings are not a prerequisite to finality because the reinstatement is not a mechanism by which the students can obtain review of DHS's decision to terminate their status for their alleged fraudulent enrollment. Despite the government's argument to the contrary, there's nothing in the reinstatement provisions that permit the USCIS to review a prior termination order issued by DHS. Rather, the former students will first need to re-enroll in another school and then demonstrate that they satisfy the remaining criteria for reinstatement. Even if the students are successfully reinstated by USCIS, they will have achieved that status without ever having undergone review of their initial termination and fraudulent enrollment decision. Accordingly, reinstatement does not provide an opportunity to completely wipe away a prior agency decision, nor does it provide a step that the immigrant can take to have an action reviewed within the agency. So that was good stuff. They go on to say, we also disagree with the district court's conclusion that terminating the student's status was akin to an initial administrative action that begins an investigation, and therefore was not final. The government relies on this position on appeal and attempts to analogize this situation to cases involving, for example, termination of asylum. The asylum cancellation statute illustrates why the termination in this case is final, as opposed to the termination of asylum, which does not consummate agency action and thus is not final. When the government terminates asylum status, it must necessarily initiate removal proceedings. During those proceedings, the former asylee may contest the termination in front of an immigration judge or reapply for asylum. The provision regarding termination of an F1 status contained no such analogous requirement that the government initiate removal proceedings. Indeed, as the government concedes, some of the plaintiffs here have yet to have removal proceedings initiated against them, even after their F1 status had been set to terminated. Unlike the situation with asylees, each student's status was terminated without any proceedings ever been initiated. That clearly distinguished the student's procedural path from that of an ex-asylee. Accordingly, we hold that the termination of the student's F1 visa status in the manner that occurred here is not akin to the initiation of the agency's decision-making process. Rather, it is a culmination of that process. Also, we disagree with the government's contention that the agency's action is not final, because the students can't obtain review of any denial of reinstatement during removal proceedings. This argument fails for two reasons. First, as we stated in Pinho, the finality of an order cannot be conditioned on something that may never happen. Accordingly, as we held in Pinho, that other case I haven't talked about here though, uninitiated removal proceedings cannot be a prerequisite to finality when there is no guarantee that such proceedings will ever occur. Moreover, we do not agree with any suggestion that a student is not really harmed if no removal proceedings ever occur. We therefore reject any such claim as bearing on our finality inquiry. It is highly unlikely that any student will simply be allowed to remain here. Moreover, even if that were to happen, we do not think that any such student should be forced to permanently endure remaining here with the threat of an imminent removal and all of its attendant circumstances permanently hanging over their heads. Secondly, removal proceedings do not offer an opportunity for review of the denial of the reinstatement. Although we have never addressed the issue precedentially, the BIA and our sister circuits of appeals have held that removal proceedings cannot function as review mechanisms for reinstatement proceedings. We therefore hold that the removal proceedings cannot serve as an opportunity to review the USCIS's denial of reinstatement because neither immigration judge nor the BIA have jurisdiction to review those decisions. And they ended with, it would be cruel irony indeed if we were to follow the government's own flip-flop on that characterization to deprive us of the ability to review the disputed governmental action, an action which, as we have explained, will almost certainly escape review absent an exercise of Article 3 jurisdiction. Rather than allow the government's change in position to inure the government's own benefit, we believe the flip-flop underscores the need for judicial review of a decision that would otherwise escape review by any court or agency. We therefore hold that this case, as currently comprised, is ripe for review and will remand to district court so that this record can be developed. So it was a sweet decision. Hat tip to Ira Kurzban and his firm and the people involved with that. This fake university thing was terrible because, if a student overseas, someone tells them that, it's a school, they have CVIS power, they can go in the system and do this, they're going to assume that it's real. Now, if they came here and there was no classes and stuff, they should have thought twice. But at the same time, this was an entrapment, the government doing this kind of stuff. There's much better ways to catch students that are doing visa fraud. There's enough schools that are doing that than to be lazy. I think this is really a lazy way of doing it, having them come to them instead of doing investigation. So no need to be lazy. There's enough student visa fraud that's definitely occurring that you could pick up on it. It's very simple to do. So I'm glad that the court there pushed back. It was good work, and they had some precedential language now about the finality of reinstatements and filing suit and all this kind of stuff that can be used for practitioners in the future. Fortunately, the federal courts are where immigration court has to happen. Immigration practice has to happen nowadays. It's just every conversation with immigration lawyers ends with federal court, starts and ends with it. So that's just the next couple of years of how an immigration practice should be, and I'm going to do my best to give you the information you need to help you in that process. So that's it for today. I hope you guys enjoyed this episode. I hope to have a new one for you soon. Have a good one. Bye-bye.